Good morning, everybody. We'll get this kicked off. First, I want to thank everybody for attending this presentation of contracting labor laws for nonprofit grantees. I'm Pat Mulligan, the Director of the Office of Labor Standards Enforcement. I want to acknowledge the staff who will be presenting today: Beverly Popek, Jade Santiago, Bernice Casey, and Maura Prenderville, as well as all other OLSC staff who helped to put this together. I do want to encourage individuals to check out the OLSC website, which is a great resource for all of San Francisco labor laws. We have more than 30,000 hits a month on the website, so it's very active. If you do have questions, our hotlines are staffed regularly, as well as all of the email accounts. So you should get responses in real time or within one business day. I also want to acknowledge all the great work of the staff that have made this office such a success. At this point, I will turn it over to Beverly Popek, who will lead off with the first presentation. Thanks, Beverly.
Thank you, Pat. Good morning, everyone, and welcome to our citywide and contracting labor law webinar, specifically for nonprofit grantees with the City and County of San Francisco. My name is Beverly Popek. I'm a Supervising Compliance Officer here at the Office of Labor Standards Enforcement. You are at session 1. We have a great day planned for you, and please come and go as you wish. For this session, we will go through an introduction to citywide and contracting labor laws, the consideration of salary history, as well as lactation in the workplace. If you haven't already, you should open up your chat box. You could find that at the bottom right-hand side on your screen. You can see where that is and what it looks like. If you open that up, you will get information that will correspond with the presentation. In addition, I know that Joyce just popped the URL to our program for the day, so you can plan your sessions as you'd like. So the slide deck and a recording of this webinar will be posted on our website. This is where you'll find it. There's many ways of finding this information on our OLSC website. Just give us about 24 hours and we're going to have the materials and recording for you on our website. Asking questions and getting answers. You can ask your questions a couple different ways. Number one, you're welcome to use our questions and answers box during the presentations, as you could find it on the bottom right-hand side in your WebEx program. We will answer questions during the presentation, and staff will select some of your questions to be answered during our live session, which will happen at the end of each presentation session. If we don't answer your question in the questions and answers box, or perhaps during the live session, we will email you the answer to the email address you used for the registration to this webinar. So if you want us to email you to a different place, please put that information in your question. Now, some questions may require more information and you may be asked to contact us, and you're always welcome, as Pat said, to contact us directly at the specific unit you have questions for example, via email, or you can definitely give us a call at our phone numbers. So here we are. We're at session 1. We're going to go through these 3 items. I'm your host and presenter for this particular session. Jade Santiago is in the questions and answers box, and Joyce Soro is in the chat box. So let's kick it off with giving you a background about what are the citywide and contracting labor laws specifically for nonprofit grantees. And this is important to understand that this webinar is tailored specifically for nonprofit grantees, meaning the information provided is customized just for nonprofits with grants. If your organization have other types of contracts, which could be contract for services, sometimes professional services contracts, permits, leases, etc. There is, and maybe other information that you have to learn to ensure that you're in compliance with labor laws specific to those types of contracts with the city and county of San Francisco. So this is the most commonly frequently asked question before we get into any sort of labor laws and whether it's relevant to your organization. The location of your company's headquarters. Does it matter where your company's headquartered to determine whether or not you have to comply or follow these labor laws or requirements? The answer is simply no. It doesn't matter where your company's headquartered for determining any of the information that's we're presenting and that's applicable to you. What does matter is your employee count. And before we dive in, this is the important question you have to ask yourself is you have to determine how many employees do you have in your company and how do we figure that out? Your employee count includes everyone working for you anywhere in the world. It's a global count, regardless of whether the people that work for you are in San Francisco, outside San Francisco. And sometimes people get this confused, but it's really simply anyone and everyone who works for you. That does include temporary, provisional, on call, seasonal, casual. There's a lot of different terms for different types of employees, but if they are an employee by the IRS definition, then you need to count them as your employees. And once you know how many employees you have, you can figure out which labor laws you must comply with. And for all of these presentations today, as well as the program, if you take a look at the program, it is organized, our day is organized by how many employees you have. So this session, when we get to our labor laws and requirements, are for all employers, meaning employees with at least one employee. So all employers are included here. So let's get started. There are two types of labor laws that you have to understand for the city and county of San Francisco. On the left-hand side, we have citywide labor laws and the right-hand side contract. You all have contracts, grants with the city and county of San Francisco, and that is tells you specific labor requirements that you have to abide with, comply with per your contract with the city and county of San Francisco. In addition, if you're operating, you're doing business, you're performing services and work in the city of County of San Francisco, you have to understand that there on the left-hand side, there are citywide labor laws that you also have to comply with. Now, you'll see today that some of your contracting requirements and labor laws are actually the same as some of the citywide labor laws. It's not to confuse you, but just giving you a heads up that they're probably one and the same. So again, you must know the size of your company, your employee count, so that you can figure out which labor laws are relevant to you and to get the most out of today. So this is an overview of the nonprofit contractor labor laws that may be applicable to you. And it really depends on how many employees you have. So for all employers, on the left-hand side, we have the consideration of salary history. If you have 5 employees or more, you need to add the minimum compensation and fair chance ordinances. Notice there are some asterisks for the consideration of salary history and fair chance. These two are also required for companies operating in the city and county of San Francisco, those citywide labor laws. Minimum compensation ordinance is a compensation labor requirement which trumps citywide labor laws such as minimum wage and paid sick leave. And then if you have work specific requirements in your contract, for example, if you have to provide security services, janitorial services, or construction, a part of your services, your grant with City and County of San Francisco, you need to know about work-specific labor laws such as prevailing wage. Most of you don't have that. It's a tiny fraction of you, but we do have some information on prevailing wage. And moving on to our citywide labor laws. Our citywide labor laws, we have a lot. You're going to see some duplicates here, as I mentioned. On the left-hand side, all employers have to comply with minimum wage, paid sick leave, consideration of salary history, and lactation in the workplace. I mentioned before that we have our contracting laws that supersede perhaps minimum wage and paid sick leave, and that would only be for the employees covered under the minimum compensation ordinance. In other words, the people, the employees working on the contract. All other employees working and operating in the city and county of San Francisco are subject to the citywide labor laws that you see here on your screen. Once you have 5 or more employees, you add the Fair Chance Ordinance, which is also a contracting labor law and requirement. And then 20 or more employees, you add the family-friendly workplace, paid parental leave ordinances. If you have 50 or more employees, you have to comply with the Healthcare Security Ordinance. And when you get to 100 or more, we add a Military Pay Protection Act, which is one of our newer labor requirements, as well as the Public Health Emergency Leave. The slides and these charts that you see are all going to be available with the materials that will be published within the next 24 hours on our website. So which laws do you have to comply with? You saw a bunch of charts. There's a lot of labor laws, contract and citywide labor laws. So this particular slide helps you stay focused. First, you got to look at your contract laws. Do they apply to you? You have to ask yourself that question. For example, is it in your grant and the information we provide today? Most likely yes. And are you a covered employer? Do you have, what's your employee count? Do you have 5 or more employees? Do you have 20 or more employees? That's going to help you determine whether or not that contract labor law is applicable to you. And if it's yes, yes, okay, then you follow that contract labor law. But if by chance it's no, no, I am not a covered employer or I don't have any covered employees under the contract labor law, then you need to look at if you're operating, if you're doing business in the city and county of San Francisco and you follow your citywide labor law. So it's one law or the other, contract or citywide. It's not both, and they do interact that way where the contract one you look at first. So these are the two big categories of contract labor laws that we have. I mentioned prevailing wage, which we have on our left-hand side. These are work-specific labor laws and requirements that very few of you have, but I want to mention. And then on the right-hand side, this is a majority of where you all fall, where you have to comply with our minimum compensation ordinance, which is MCO. So let's take a look more at these. You're not sure where to start because maybe you're new at this or you need to refresh. We have everything on our OLSC website. And on our website, you can take a look at what we have here is work-specific labor laws, our prevailing wage laws, 102, which is construction related, and 101 to 109, which is non-construction related. So most of you, you're nonprofits, you're thinking, oh, I don't think I have anything to do with construction, but let me brainstorm here. So perhaps if you're putting together a proposal for a street fair, a festival, and you're going to build a stage, you're going to do something like that. Well, maybe there's construction related. That's a question for you. Now, prevailing wage 101 or 109, it says non-construction. That can mean a lot, but really relevantly and more specifically to folks attending today, nonprofits with your grants, this would be janitorial services as well as security guard services. So if you have to run a navigation center or you're somehow involved with a grant that provides money in your grant to provide janitorial services as part of the grant, then yeah, you got to look at your prevailing wage requirements. The same thing with security guard services. Maybe part of the scope of services you will perform for City and County of San Francisco requires security guard services. Then you got to look at prevailing wage. But these labor requirements, these laws are only for janitors, and security guards. Everyone else is going to fall under the minimum compensation ordinance. So that is really what this next slide is all about. If the work is not under prevailing wage, because prevailing wage is super work specific, construction, and for you folks, probably janitorial and security guard services, then everything really falls under the minimum compensation ordinance, MCO. So again, the methodology is super specific. Determine if you're a covered employer by how many employees you have anywhere and everywhere in the world. And after that, you have to figure out your contract laws and who are the covered employees, the people working on the contract that you may have to comply with, and you can make a list. And then after that, you can also figure out people who are not under the contract, who just work on maybe non-funded programs, non-funded city uh, programs in your organization. So here are some examples of work and contract labor laws and which ones are which. So again, work-specific stuff like construction, building a stage. I think that's that's the most relevant that I could think of for nonprofits that I've seen most recently. That would be prevailing wage. If you have to perform and provide janitorial services or security guards per your grant, per your contract with the city and county of San Francisco, then it would be prevailing wage. Now, stop right there. Let's just say you have a nonprofit, you're located in an area where you need a, a security guard, but you have no city funding, no city grant and contract to pay for the security guard that you employ to provide security services for your nonprofit. That does not fall under prevailing wage. They're not working on a contract by the city and county of San Francisco. So you need to look at your citywide labor law for that particular employee who provides security guard or security services. So that's the difference. You have to take a look at your contract first, and your contract will dictate. Now, as I mentioned before, a majority, 90% of all of you and your folks, the people that you employ, would be under the third bullet point here. You have administrators, office staff, counselors, consultants, outreach workers, case managers, performers, architects, engineers, nurses, project managers. All of these people would be under our minimum compensation ordinance, MCO. And we have our presentation on MCO a little later today, so take a look at the schedule. So wrapping this up in terms of just having an introduction between our contracting and our citywide labor laws, let's look at some tips and best practices. I'm kind of redundant, but you got to look at your contract. So number one, based on your contract, you will be able to figure out the contract labor laws that are relevant to you. You have to look at your scope of work, what what are you being funded to perform and do? The scope of work in your contract will understand and define which positions are covered under the contract labor laws. So the contract labor laws are only for people working on those funded programs by the city and county. And then the second part about all of this is, do you or will you operate in the city and county of San Francisco? If so, you are going to need to get information on the citywide labor laws, and there may be some interaction. Three, get information on each law to determine, are you a covered employer based on your size, and who are your covered employees if you have any? And then, of course, if it's all yes, yes, I'm a covered employer and I do have covered employees, you have to ask yourself, what are the requirements? And of course, options for compliance, because you do have options. And thank you again for coming today, because you're understanding your requirements and options. And four, we want to tell you and remind you that we have a lot of resources available to you from the Office of Labor Standards Enforcement. We have video on demand at lots there for you. It's a library. We have our website, and as much as we have there, sometimes this can be super overwhelming and sometimes complicated. Don't hesitate to reach out to us. And how should you do that? The best way to do that is you need to start somewhere if there is a labor law, labor requirement that you have questions about, for example, could be healthcare security ordinance, you would go to that particular web page to get contact information for that unit and reach out directly to that unit to ask your questions. A lot of times, having a phone call may be very helpful because there may be follow-up questions that we need to ask you to answer your question, and you do have options. So that's most effective and efficient if we have a call or we meet virtually, and you can always meet with us in person. We're located in City Hall. If you do that, please give us a call, make an appointment so we can meet with you and get things ready for you. And this is where we are. We're in San Francisco City Hall in room 430, open 5 days a week, 9 to 5. So that is basically an overview of our contract and citywide labor laws. Let's move into the consideration of salary history ordinance. And this one is a contract as well as a citywide labor law. So again, you're all here, you have grants, so this is within your grant, as well as this is a requirement for any company organization performing work in the geographic boundaries of San Francisco. All employers are covered under this particular requirement, this ordinance, and except for government entities. And that's something to understand. And then San Francisco here on this slide has a little asterisk. You've been hearing me say geographic boundaries of San Francisco, the city and county of San Francisco. That's because if you take a look at the bottom of the slide, federal enclaves are not included or a part of the city and county of San Francisco. And federal enclaves is federal land, federal places such as the Presidio or Fort Mason. Also, heads up, the San Francisco International Airport is not considered San Francisco, not considered in the geographic boundaries or the city and county of San Francisco. So all employees working within the city and county, the geographic boundaries of San Francisco, no matter what their position title may be, includes part-time employees, are covered. So you have to count all those folks and they're covered under this requirement. So what is a salary history ordinance all about? It's a super simple law. So let's go over the key provision. So the first item that you have to understand is that you cannot ask applicants about their current or past salary when you're interviewing, when you're hiring someone for a position. You can't ask this information on the application, a text, an email. You can't infer that you want to know this information. Just don't do it. Don't do it. So that's the first item. The second item is number 2. You may not disclose a current or former employee salary history without that employee's written authorization, unless the salary history is publicly available. So what that means is if I am in your employ, I'm working for you, and perhaps I'm seeking another position and I put you down as a reference. The person calls, hey, do you know Beverly? And hey, do you know what is Beverly making? What are you paying her right now? You're not supposed to disclose this information unless your employee gives you authorization, and it needs to be in writing. So please, you can give this information, but you should have the permission of that employee in writing. Now, number 3, if you're in that job hiring process, which you're often involved in, and you have applicants, and sometimes it happens where an applicant chooses to share their salary information voluntarily, tells you that, oh, I'm making X amount right now on an annual basis. And that may happen. It's very common. Now, if that happens, if the applicant does so, then you may consider the information in determining the salary to offer the applicant. It means you can follow up, but you can't start, you can't prompt, you can't ask. I want to be clear about that. And if this does happen during the process, when you're hiring someone, please make note of it. The date, time, any witnesses, when and where did this happen? Because if there's any questions later, we will want to know whether or not there was a violation to this particular ordinance. So the best practice is that it's all about the hiring process. Don't inquire about salary history, such on the job application. So if there is a space for that on your job application, just please get rid of that question. And that's one way to avoid violations and compliance issues. And you're here. I'm glad you're here and you're watching this, but please inform and educate everyone in your organization about this particular requirement under the consideration of salary history ordinance. They may serve on the interview team and they don't understand that this is a requirement in law. Please let them know and share this information. In closing up for this particular ordinance, this is our website, our phone number, and email address. So, and then Joyce just popped that in the chat box if you need that. So moving on over to lactation accommodation in the workplace. For this particular ordinance, again, all employers are covered, meaning you have to comply, except if you're a government entity. And who are your covered employees? It's all employees working within the geographic boundaries of San Francisco. This is the exact same slide and information as consideration for salary history. So the purpose of this ordinance is to provide a supportive work environment to enable employees who are nursing mothers to breastfeed or express breast milk during work hours. It complements state and federal law as we amended our police and building codes. So what is this all about? What is this requirement for this particular labor law? You must provide a reasonable amount of break time for employees to express breast milk. Now, the break time, if possible, can run concurrently with any break time you already provide to the employee, although you need to coordinate and speak to the employee about this and see if this is going to work. Lactation is not something you can push a button and it comes on and off. It is linked to schedule and when it's possible. And this can also change over the course of time. So please talk to your employee about the break time. Now, the break time you normally give the employee may or may not be adequate for that person to lactate completely. So if there's any break time that does not run concurrently with the rest time authorized under state law, it may be unpaid. And you need to discuss that with your employee. So location, you need to provide a location for lactation and it can't be a bathroom. It needs to be shielded from view, free from intrusion. There's a lock, it's safe, it's clean, contains a surface. So if that person has supplies such as a pump and other items that can be on the surface, there needs to be a place to sit. And the more comfortable the chair, that you provide, I think the most effective it would be for the person to lactate and get business done. You need to also have access to electricity. If there isn't a plug, I know employers have run very long extension cords. And again, it's not a bathroom. If you're in a multi-tenant building and you cannot satisfy this location on your own, you can have a shared location where there is a lactation room in your building. However, all of these things must be provided in close proximity. And note that close proximity, there is an asterisk. And to the employee's work area. And you also need to provide access to a refrigerator and sink with running water. So I want to pause right there on the refrigerator and sink with running water. The refrigerator does not have to be in the lactation room. The refrigerator does not have to be a separate and different refrigerator, although some employers and employees, not including the lactating person, prefers that. The sink with running water does not have to be in the lactation room. It can be elsewhere, but it has to be in close proximity to the employee's work area. And I'm saying close proximity, this slide really unpacks and breaks it down. This definition of close proximity really depends on the specific of the situation, but it has to be close enough. A location has to be close enough that it does not deter a reasonable person from using any and all of these items, such as refrigerator or actually the lactation room. Um, so let's see here. I'm moving on to one of the requirements of this law that a lot of people don't know. You need to have a lactation policy. This is a requirement. And within the policy, you have to identify the process by which an employee may submit a request. Perhaps you have a request form. If you don't have a request form, go to our webpage and we have a sample form for you to use and to customize. When you receive a request, you must respond within 5 business days. Document everything, keep all of your records at least for 3 years, just in case we have any questions. And you must engage in an interactive process with the employee to determine, number one, the lactation break period or periods. Maybe that person needs more than one lactation break, as well as the location and specifics of that. Think of this as a reasonable accommodation request to try to understand and to accommodate as best as possible. When you can accommodate, you need information about denying the process. So if you deny the request, you have to provide a written response that identifies why you have denied the request. So let's talk about some reasons how and maybe why you might have to deny the request. Now, you can establish an exemption from the requirement of this ordinance. And mind you, we are city and county of San Francisco. We're on the city level, requiring you to provide breaks, lactation breaks, and or a space if it's possible. But such exemptions that you may bring up or establish may not be available under state law, and we are in the state of California. So that said, you need to understand you must comply with all requirements of the ordinance that you don't have an exemption from, as well as any and all state and federal legal requirements that you need to look at. So let's talk about the exemption under the city-wide and our local ordinance here that we're talking about today. The exemption that you can perhaps use if this fits you is that maybe you have an undue hardship. And what is an undue hardship? Let's look at the definition. It's a significant expense, operational difficulty when considered in relation to your size, financial resources, nature, or structure of your business. So the an example of an undue hardship may be where you have to build a room. You don't have a room. That could be challenged. Maybe you have a multi-purpose room that can be converted into a lactation room. So that is one example that may be for you. Now, if you have an outreach worker who is, 99% basically working on the streets of San Francisco, that person's environment it would be the streets of San Francisco, and that might even be an exemption as well. That's one of I would think one of the most relevant examples I could think of with a lot of the folks attending today in a nonprofit situation. So let's talk about some best practices. I really want you to think about learning about lactation. Learn about lactation, understand what it is, what it isn't, and how it works. It's not something you can push a button and it just happens. With that background information, when you are engaging with an employee in a reasonable accommodation, a good faith process, it's going to make that communication, that process, so much easier for you. You can also watch our on-demand lactation in the workplace video for more information about this particular ordinance. And you can use the sample policies on our website to make your own if you don't have one. If you have some, you can always tune up and take a look. And definitely look at our rules and regulations on our website, as well as our frequently asked questions on our website to, I guess, tune up or If you don't have that policy, if you don't have the procedure in place, create one. With that said, you need to have the policy. It is the law. You should have one right now, and if not, create that very soon. We're here to help you understand the requirements as well as maybe help you understand what options you have based upon your particular situation. Once you have that policy, the best practice is to distribute the policy at the time of hire. And if you don't have it, and you have it like tomorrow or next week, issue a memo with a copy of the policy to current employees. And the next time you have a refresh, a new version of your handbook, make sure your policy is in the handbook. Now, retain records. I mentioned this before. You should retain records for at least 3 years. So if someone makes a request, keep all of those items for at least 3 years. And please contact us if you have any questions. We are here for you to help you understand your requirements as well as your options. This particular slide has just some general information about where to find our webpage. And we have all of the resources available to you, as well as our phone number directly to our unit and our email address. So right now, we are at our live question and answer session. If you haven't sent in a question that you want to ask, now is the time. I know that Jade's been sending answers, posting answers in that questions and answers box. If you joined us late, feel free to open the questions and answers box and you could see questions and answers. And again, if the question is not answered during the webinar and or this live session, we will email you the answer to your email address you use for the registration to this webinar within the next 24 hours. So hey Jade, how are you?
Hi, Beverly. Thank you. Good morning, everyone. So we did receive some questions, starting from the beginning with the charts. Somebody really liked the charts with the information about the labor laws, and they're asking where they can get a copy of these charts.
Oh yeah, that's a great question. So the charts that you might have seen for citywide as well as contracting labor laws will be found in the slide deck. And we're going to post our slide deck with a recording of this video on our website within the next 24 hours. So you can find those charts in the slide deck, and that's where you can get a copy.
Thank you. This one is regarding salary history. Does this law apply to my subcontractors?
Yes, so all of your contracting labor laws that you have in your grant applies to you as the contract holder, as well as any subcontractors that you hire to perform services for your grant, your contract. Now, with that said, your subcontractor would have to go through the same sort of questions and process that we went through this morning. For example, number one, am I a covered employer? If I am a covered employer, if the answer is yes, do I have any covered employees? So that would be something that your subcontractor would have to do. And what I would say is if you do have subcontractors and now you're realizing and I'm reminding you that, oh yeah, you have subcontractors and these labor laws do apply to them, you should remind and tell your subcontractors about these labor laws. And we are here as a, place for them to come to so we can work with them directly. Because as a prime contractor, as a holder of that grant, you are responsible not only for your compliance, but also for your subcontractors' compliance. And when I say compliance, I'm thinking in a positive light that everybody is following the law, doing everything that's supposed to be. But sometimes folks don't do that, and you would be responsible for violations.
Thank you. Do we have time for a
Yeah,
couple more?
we have
Okay.
we have time for a couple more.
Okay, another salary history. We have a lot of turnover at our organization, and we are asked by former employees to provide references. What should we do or not do regarding providing salary information when we provide references for our former employees?
So yeah, I mean, it's an option whether or not you're going to, I mean, I've heard of companies where they don't want to provide any sort of commentary or references and speak to a prospective employer or something like that. But I mean, if a former employee is asking for this and they're going to authorize and put it in writing, it's okay to release the salary information for that person. So, I mean, I think it's up to you if you want to provide it. It's just like an option. There's no law requiring you to, but if that employee is asking you to, that's up to you, and definitely get their permission in writing.
Okay, thank you. Here's one for lactation. We don't have a lot of space in our organization, but we have a meeting room and we think we can use it as a lactation room. How does that work when it's a multi-use space?
Oh, that's a great question. So, yeah, everybody has some sort of meeting room, and space is really difficult to find in San Francisco. So, yeah, you can use a multi-space room, and best practices is that you need to work out some sort of schedule with your employee who will use the room as a lactation room, and you're going to have a lock, and I would put a sign so that all other employees will know that, say, from 10 to 10:30 in the morning, that room is unavailable. And the priority would be for that room used as a lactation room. So making those special, um, you know, accommodations and scheduling the room, making signs, making sure there's a lock, because you wouldn't want someone to walk in anytime they can just open the door. Having a chair, having a surface, and making sure it's clean. All of these things can be done with some planning. Now, I mentioned before that although you may make a schedule, an arrangement with that employee, it could change over time. You need to speak to the employee, and they should also speak to you if it needs to be changed, so that everything can be organized and scheduled appropriately. Yeah, Jade, I think we have one more minute. So I don't know if there's a quick question, if there's one.
Does lactation room need to have a sink?
No. So,
Okay.
yeah, your lactation room does not need to have a sink, but you need to provide access to a sink that is relatively close. And then for all of these, especially for lactation, these last couple questions, it's on a case-by-case basis. And I'll be very honest with you. Jade and I work in this particular unit. If you have questions, schedule a time with us and we'll go through your questions, and we'll need to know some more information to give you an answer, and of course some possible answers and things to think about. Okay, well, great. And then I know we didn't get to answer all of your questions. We will email you back those answers within 24 hours. And I want to thank Jade. And our next session is the minimum compensation ordinance. We're going to start at 9:45. And so we have a break. Thanks again. Soon.